7:44 is our time here on Sky 99.5 FM, and we're heading into more newsmaking in this, the second hour of the Breakfast Roundtable. On the line with us, attorney at law and member of the Police Service Commission, Martin George. Good morning to you, Martin George.
Hi, good morning to you, Jessamine. Good morning, Dr. Wayne. Good morning, Edison. And good morning to your listeners.
So, Martin George, interesting developments on the legislative agenda. A promise, more or less, from both the Attorney General and the Legal Affairs Minister that there are certain critical bits of legislation they will ensure are pushed through Parliament and made into law. And listed among these, the Indictable Proceedings Preliminary Inquiries Act, the Electronic Transaction Act, the Data Protection Act, the Cybercrime Bill, and they're also going to be looking at drafting legislation to ensure that the appointee to the Commissioner of Police post is a TNT national. That's a huge undertaking, isn't it?
Well, yes, it is a wide range of different pieces of legislative instruments that they would need to look at, because you would possibly need to look at constitutional amendments, because anything touching upon the function and role of the Police Service Commission is part of the Constitution. We are a constitutionally appointed body, and they would have to look at those types of changes to effect this. It would also mean that they would require some level of opposition support in regards to these changes. And this goes beyond just the question of whether there's a legal requirement for the support or not. The idea would be that to make such fundamental changes, it's something that you would want the buy-in of the other side. You wouldn't want to, railroad your way through Parliament with legislation like that without there being some kind of general consensus. So I would imagine there would be some horse trading across the aisle to try and ensure that whatever is arrived at is something that both sides would agree upon.
This new change, Mr. George, for the process of the appointment of a commissioner, it must be a local and so on. Would you applaud that as you're a member of the PSC?
Well, the thing is, I wouldn't wish to comment as a member of the PSC. I don't think it would be proper or appropriate for me to comment in that capacity. But as a citizen of Trinidad and Tobago, I could say that I have always been of the view, and I've shared this publicly, so it's no secret, that we have more than enough talented nationals, whether resident here in Trinidad and Tobago or abroad, who are more than capable of filling that role and doing a good job. So the point is, there was never any, mandatory, requirement that to say that you must choose a foreigner, or even a mandatory need for a foreigner based on the lack of available talent among Trinidadians and Tobagonians. So, entrenching it in the legislation, I guess that just reinforces the view that I have shared. But the point is, we always have had capable people who can do the job.
But there are capable people also, Mr. George, who can interview possible appointees and so on and do the work, perhaps in the civil service, because I'm seeing here that part of the whole new process would be some local firm to do the interviewing and the selection process and so on. Couldn't this be a job for the civil service? Suitably qualified people.
Well, the thing is, yes, it could be also, but the thing is, I think the mischief they were trying to get at is what is actually currently bedeviling us, because under the legislation as it stands currently, the requirement is that you must choose a firm that has experience in the recruitment and selection of senior police officers. So the thing is, when you look at the local landscape, it's difficult to identify any local firm which can really put that on their resume to say that they are experienced in that regard. Hence the reason in the past we ended up with the Penn State as the choice of the firm. So I think they're also looking to deal with that, because currently we have been stymied in that we haven't even gotten off the ground with the selection of a firm yet. It's been more than 2 years, and we have been waiting. And the unfortunate aspect of it is that the public would ask the questions and say, what is the PSC doing? But it hasn't even reached back to us yet. So for more than 2 years, it's been in the hands of NIPDEC, which has been appointed to try and select a firm. And they have not even completed that process yet. So the thing is, nothing can go forward until that firm is selected. That firm then has to do its interviews. That firm then has to produce a short list. And it's only then the PSC gets back involved when that short list is produced. So I think that the whole idea is to try to circumvent all these, bottlenecks in the current legislative agenda.
Mr. George, I want to just bring in a new perspective here into this, to pick your mind, first of all, and bring into the fray here this release of the alleged charged Ricardo Jerome Keys, that he, the beating accused, if you can recall, that was on social media. He's been released by the magistrate. Is it because of the charges, that the charges that was laid against him are lesser charges than some of the other charges, or is this a privilege to him that will set precedent for others? How does this work? This is a first that we've seen?
I would imagine that the magistrate would first of all have been guided by the provisions of the Bail Act. And let's understand that unless it is something such as murder or treason, which is clearly a non-bailable offense,
right,
then even for what we may consider very heinous crimes and very what the public may think to be obvious and egregious breaches of the law, you are still constitutionally entitled to have an application made for bail, and depending on the conditions that the court may set, you may be granted bail on those circumstances. And then we must always remember, notwithstanding the wanton publicity which attended this particular matter, we still have to operate on the presumption of innocence. Remember, that's something that we always give to everyone, the presumption of innocence. No matter how bad the evidence, quote unquote, in the minds of the public may seem, the magistrate cannot be swayed by that. The magistrate still has to exercise that function and role impartially, judiciously, and fairly, and still give you the benefit of the doubt that you are presumed innocent until proven guilty. So I would imagine that based on those twin pillars, the magistrate would have felt that it is an appropriate circumstance to grant bail. I mean, I'm not sure what conditions were attached to it, but the point is we must always maintain that balance. You see, it's very easy for laypersons and members of the public to rush to judgment on things that they would see or hear, and that's all well and good, and they're fully entitled to do so. But when you are exercising a judicial function, you cannot do that. You must now step back and say, hey, listen, notwithstanding what people may have said or what they have claimed to have seen in a video, I, as the judicial officer, cannot be swayed by that, because that is not evidence before me as yet. So therefore, I must still operate on the basic premise that this person is innocent until proven guilty, and you look at the law, you look at the conditions set out in the Bail Act, and then you apply that accordingly. And if it falls in a circumstance where you have to grant the person bail, then you have to do so. You see, and judicial officers are very often caught in this type of dilemma, in a sense, where they may make decisions which they know that the public would react to in a negative way, but that ought not to sway you from doing your duty and your decision and your judicial function. I can give you an example. Years ago, there was a scenario in Guyana where the election was challenged, and the then Chief Justice, Desiree Bernard, as she then was, she then became a member of this Caribbean Court of Justice, but she was then Chief Justice of Guyana, and the task fell to her, leading the court in Guyana, to decide upon the election results, whereby I think it was Cheddi Jagan's party had declared that they were the winners. And notwithstanding the mood and sentiment of the majority of, I would think, Afro-Guyanese who were of the view, well, yes, this is coming before an Afro-Guyanese Chief Justice who therefore would not rule in favor of the majority Indo-based party. She ruled in their favor because when she looked at the law, she analyzed the law, she found that the law found favor with their case. And you see, this is where you get that respect for judicial officers, and you recognize that, look, they always must look at the higher principles. They must always take the high road when it comes to circumstances such as this, and sometimes they are castigated and chastised for it. But then you recognize in hindsight that history absolves them. You look at somebody like Lord Diplock, who was always a trailblazer in the law in England. I mean, he was very unpopular with some of his fellow law lords in England because at times he would take very controversial stances, and he would always seek to stand up on the side of the small man and, try to apply the principles of equity. Lord Denning was also another trailblazer and a judicial luminary in the United Kingdom, and he also would sometimes stand up and make very unpopular decisions. But then years later, others would come around to understand the view that he has taken. And that's why I said, when we had the results of the Court of Appeal decision in the recent election issue with the party, with the UNC and the
petitions,
PNM,
yes.
The fact that we had a minority dissenting decision of our Chief Justice, I think it's very good for our jurisprudence that you have judges who are able to stand robustly independent and say, hey, listen, even though the majority may not agree with me, this is my view, this is my reason for it, and you set out your reasons based on the law. Mm-hmm. And it is something that, who knows, maybe later, years down the road, it may be proven that you were the right one, even though you were in the minority. But the point is, once we apply the principles and we stick to our analysis and understanding of the law, then we can never go wrong in terms of how we deliver our, judgments and your decisions.
Now, part of the condition for the bail, the order of the court is that the accused should not come in contact with the victim. But here we see the victim wants him, as the child's mother, to be a part of that family unit, as it were, over the Christmas season. How is that going to work? If he violates that, what will happen with the bail?
Well, the point is, his first and foremost duty would be to the court and to obey the directives and the order of the court. So if the court forbids you from coming into contact with the victim, then, with the alleged victim, then you have to obey that. It doesn't mean that you can't spend time with your child. So maybe you could arrange for a third party to, drop the child, at some neutral venue where you can spend some time, or drop the child by you and you spend some time and that person take the child back. So it doesn't prevent that. But if it is that the court orders that you stay away from someone, then you have to abide by that. Otherwise, you get your attorneys to apply to the court to seek a variation.
I think this is what happened.
Right. So if you don't get a variation, then you must abide strictly by what the court says.
Martin George, unfortunately, we have to leave it there for now.
Oh, I'm so sorry. We were now getting it.
I know. We have to go to news, but okay. Thanks for squeezing us into your morning.
Sure, no problem. All right.
Okay.
Look forward to chatting with you guys. Take care.
Keep it right here on Sky.
Don't touch a button. We'll be right back with more on Sky 99.5